I'm opening the executive session on House Bill 1050, and we're just going to recess it for a couple minutes until the rest of the members get, once we start, just recessing it for a minute until we get everybody in here. Everyone who's here, we're just waiting for a couple of amendments before we start the day. mind, please rise and join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Everyone would please excuse the delay. We had a member sick this morning, so we had to kind of re-plan everything we were doing. So with that, I am opening the public hearing, the executive session on House Bill 1050, and I recognize Representative Muse to make a motion.
Thank you, Mr. Chair. I recommend HB 1050 ought to pass.
Can I have a second?
Seconded.
Motion made by Representative Muse, OTP, seconded by Representative Murray. Representative, would you like to speak to your motion?
Yes, briefly, in most parts of the country, including New Hampshire, there is no ability to voluntarily add yourself to the federal firearms background check system. What this bill would do is change that by establishing a voluntary do not sell list in the state of New Hampshire for people who wish to voluntarily waive their firearms rights. I think we heard some emotional and poignant testimony during the public hearing for this bill. I also don't think we heard any serious objections to this. From a libertarian standpoint, this is essentially what this bill would do is the most libertarian thing ever. It basically gives people control over their own destiny. It lets them make the choice. And this is vitally important for people who suffer from episodic mental illness around things like severe depression, bipolar illnesses, and things of that nature, who may be totally in control of themselves at one point, and then not so much at a different point in time. What this essentially allows them to do is to take the most lethal potential form of suicide off the table, but only for themselves. And what it also allows them to do at a point where they feel better, where they feel more confident in their abilities, where they feel like their mental health has improved significantly, they can get themselves off the list. So bottom line, this is a bill that actually increases freedom for some people and the ability to make a choice that they want to make on a voluntary basis. So I would urge you to pass it. Thank you.
Thank you. Representative Murray, would you like to speak to your second?
I would just affirm what Representative Muse said, and that if people are looking for a way to protect themselves from themselves, we should give them the ability to do so.
Thank you. I'll start discussion by saying that I think I can speak for the minority present today, that at first blush, this seemed like a good bill to me. It seemed to make sense. But during the testimony, I particularly was taken aback by the testimony from the New Hampshire Medical Association when they testified that they liked it because it helped their to further the end that they testified was their goal was to obtain lists of people that own firearms, and I found that rather disturbing. And I also, some of the testimony we heard was concerning with regard to potential to influence people to put their names on this list when that may not necessarily be what they want. I realize that the bill has some guardrails against that, but they would be probably very difficult to enforce if someone's doctor said, you need to put your name on this list if you want to be continued to be treated by me, or things of that nature. So for that reason, I think that we would not support it. Further discussion. Representative Stone.
Thank you, Mr. Chairman. And I'd like to say that this bill is a red flag bill It also creates a penalty for an individual who is voluntarily doing something, which is kind of disturbing in itself in the language of the bill. Furthermore, I really think creating a registry, even voluntarily, is a slippery slope when providing your personal information to any government entity, and it may have unnecessary consequences in the future if that information happens to be retained. And there is no statutory timeframes which requires an individual to submit to have their name off the list of which that would occur. Those are some of the points that I just picked up out of it that are most concerning to me.
Thank you. Further discussion? Representative Wheeler.
Thank you, Mr. Chairman. I appreciate your concerns and the concerns brought by Mr. Stone, and I share the concern about coercion. I was worried about that when I heard that in the public hearing as well. But I do think that Representative Muse has crafted legislation which was thoughtfully put through with the right guardrails in place, and I think that in my reading about this program as it's been implemented in Utah and Virginia and Washington, and the program as it's being proposed in other states, it seems to be working, and it seems to be working in an efficient way where people aren't being coerced onto the list, and where this information is being kept private from people who might use it for malicious means, and is being used to help people from going out and harming themselves when they know that when the individual know that they shouldn't have a weapon. So I share your hesitations, Mr. Chairman. As you know, I have different opinions than the rest of my team on this, but I think that this is a bill that's worth supporting, and I'll be voting for ought to pass on this legislation.
Thank you. Further discussion? Seeing none. Oh, Representative Sitek.
My objection is that I don't know that the bill is necessary, and this may not be a substance objection, but I just hate to see the body of law get expanded by another few pages. It's already enormous. Thank you.
All righty. With that, I'd ask the clerk to call the roll. The motion on the floor is ought to pass.
Vice Chair Rhodes?
No.
Representative Pratt?
No.
Representative Sitek?
Yes.
Representative Prout?
No.
Representative Jandrin?
No.
Representative Mannion?
No.
Representative Reed?
No.
Representative Stone?
No.
Representative Harriet Gathright?
Yes.
Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Sue Newman?
Yes.
Representative Wheeler?
Yay.
Chairman Roy?
Chair votes no.
11-8.
Motion carries 11-8, ought to pass. Representative Muse, I'll need your report before you leave today, please. Who's going to, minority report, Representative Stone, same, I need the report today. And with that, I close the executive session on House Bill 1050, and I open the executive session on House Bill 1186, and we'll be making a motion. Representative Newman, I recognize you for a motion.
Make the motion to ITL. I don't believe this bill is necessary. I think that merchants should label things any way they want to label them. I also think that the penalty is excessive, $10,000 for each occurrence. I don't know whether that's each occurrence on the bill or whatever it is. I just think that this bill is unnecessary.
Second?
I'll second.
Seconded by Representative Harriet Gathright. Would you like to speak to your motion? Yeah, I guess he kind of did, didn't he? Would you like to speak to your second? Discussion. Representative Jambrin.
Thank you, Mr. Chairman. It's unfortunate that the credit card companies and the Bankers Association sat with me, crafted a amendment to the bill that strikes the $10,000 and makes the person liable for that. Any penalty would be the credit card transaction company and not the credit card companies or the banks. And if you don't think this bill is necessary, I will point to the state of California, where this morning CBS News reported that they will be using firearm purchasing codes, and that financial institutions are required by state law in California to share that information with the state police. So if you don't think this is necessary in a live free or die state, I think you're sadly mistaken.
Thank you. I'd add to that I would ask the members to think, what if it wasn't about firearms? What if it was a red state and the governor was getting information from a company that was tracking, for example, purchases made by LGBTQ people or trans people, to find out who was getting operations in contrary to what they wanted, or any number of things. The government using private companies to further its ends is nefarious. It's a horrible practice to start. And I think that we need to keep a very, very close eye on that, because the big brother state is here. And when you can't make a purchase without the government knowing it and keeping track of it, that's problematic. As you can see, what has happened here in our state with our medical marijuana programs, they're all cash and carry, because the government's keeping an eye and will shut down any bank that processes any of that. So it's a, like I said, it's a very slippery slope when the government's watching what we're buying. Representative Stone.
Thank you, Mr. Chair. In regards to this bill, if you believe that an individual's right to privacy outweighs anyone else's rights when it comes to tracking your information, even your buying habits, you would support having this bill ought to pass. In addition, I think the chairman hit it right on the head, is where do we go if it's just gun rights? Is it going to be transgenders? Is it going to be other issues that come up and evolve? I think this is a problematic bill, and I think it has issues where we need our privacy protected. If we look at the New Hampshire Constitution specifically, Section 2, Article B, government intrusion is there for a reason. And again, I would urge everybody to vote ought to pass on this bill and not ITL.
Just to clarify, you weren't saying the bill's problematic, but the situation's problematic.
The situation is highly problematic where you're tracking individuals' rights to what they purchase, and the government has no right to know what you're buying.
And further, your point, we just, not just we, but the people of the state just adopted a constitutional amendment to have privacy in their effects and their information from the government, and the government is using a backdoor to get it around that amendment. Representative Wheeler.
Thank you, Mr. Chairman. I agree with what you said. I don't think it is a far-fetched idea, nor is it far-fetched to say that the government right now has become excessive in how much it is willing to trample on people's privacy rights. We saw from the WikiLeaks documents and Edward Snowden and other Chelsea Manning and other whistleblowers that have come out to discuss some of the things that the military and intelligence agencies have done when it comes to extrajudicial surveillance on the American public. And I'm very concerned. It's not a QAnon conspiracy at all to say that the government is moving forward on this. It's a well-documented and established fact. And as I think you articulated very well, Mr. Chairman, this could be used, take guns away. It could be used for any number of things, tracking people's behavior. And when we live in a state in which we have passed a constitutional amendment affirming people's right to privacy, and when we say that people are individuals and have their individual right to have their transactions private, then I think that this is a legislation worth supporting. I think Representative Jambrin has put in a lot of diligent work working with people who are going to be affected by this, and I will be voting against the ITL motion in hopes that we can bring forward the amendment that he has brought forward, and that another motion can be made.
Thank you for the discussion. Representative Muse.
So basically, what these codes would do would be to allow the banks and the credit card companies to basically support suspicious and potentially illegal activity. So a lot of credit cards have pretty high limits. One of the things that might flag the interest of the company might be a purchase of, let's say, $20,000 worth of firearms and ammunition all made at the same time. I think that there's one of the things I think we also need to recognize is that while there have been states that have passed laws that that would not allow, that would essentially disallow credit card companies and banks from gathering this information, the credit card companies themselves have suspended have essentially suspended this policy. The policy right now is under review. There's also an effort at the national level to take a look at this and to put additional guardrails around the practice. One of the things I will say that's also danger is creating a patchwork of different state laws. So New Hampshire does it one way, Virginia does it slightly differently, California does something completely different. What it does is it adds significantly to to the cost for the for some of these companies. In terms of whether or not something like this is good public policy, I don't think there's really any evidence that any of this information would actually be used to put together any kind of registry or anything like that. I mean, essentially, it's in a lot of ways, it's not very different from what social media companies do when they see like a particularly I guess a particularly crazy post from an individual that might indicate what that individual is doing harm. Social media companies are will cooperate with law enforcement in situations like that. I'm not seeing the potential for the kind of abuse that would lead you to think that law-abiding gun owners are going to be targeted for simply purchasing another box of ammunition for their handgun, purchasing another rifle for hunting. I don't see a situation like that. And I think one of the things that we need to do is try as best we can to actually make laws that respond to actual problems. And I don't think this is an actual problem. Thank you.
Thank you. I found it interesting you said that it was a law that might be used to track illegal activity. And then you said such as perhaps purchasing $20,000 worth of firearms or ammunition. One rifle can cost $20,000. And that's highly illegal. And it's frankly none of the government's business. Or if I bought 10 of those, until it's illegal, it's my right. And I don't think that the government should be able to track my rights. Representative Stone.
Thank you, Mr. Chair. I'd like to point out that anybody that holds a credit card has the option, much like in 1050, of voluntarily setting limits to be flagged if your credit card is being used in excess of either 5, 3, or whatever denomination you want to set. In addition, we already have laws in effect that if firearm purchases are illegal, such as straw purchases, they're addressed both at the federal level, which has a high degree of imprisonment and high fines attached to it. I think this is an invasion of privacy. And I know in the past I've worked with entities in my employment post 9/11 where a lot of information was gained through financials, whether it be bill paying or it be other purchases that you could get subpoenaed records on to help build a case if you so desired to. So there are avenues that have been in existence of tracking information, and this just adds to it and codifies it where we're justifying tracking people's individual rights and privacy is violated.
Members of the committee, before Chairman Roy calls on the next person, if you could all please silence your phones, your computers, whatever you have open. We're hearing a lot of dinging and donging, and it's quite disrespectful. So please turn your ringers, your volumes off. Thank you.
Representative Stone, you have a, huh? Oh, Jambrin, I'm sorry. Representative Jambrin, you had mentioned what your amendment was going to do. If it, did it address any of the concerns we've heard?
Actually, when Representative Newman had made his motion, he had mentioned a $10,000 fine. The amendment strikes that $10,000 fine and leaves the civil penalty up to the court of appropriate jurisdiction to determine that.
Any other changes to the bill other than that?
It changed so that the person that would be liable for prosecution under this is not the issuer of the card, but the card processing network. That's the two changes.
Thank you. Representative Bolden.
I was just curious if the sponsor or anyone on the committee could speak to how this would impact preventing acts of terrorism.
I don't understand the question. Maybe you could clarify it. How would it be involved in acts of terrorism?
Terrorists use weapons, and if they purchase them
So
on a credit card,
we have a,
then law enforcement might be aware.
I guess that question presupposes that everyone who buys a firearm should be screened for terrorism. What was there a threshold that you think that they should be able to see?
I don't know. I'm not
Yeah,
I'm not in the FBI, but I wonder if it would make it difficult for them to, if this coding isn't a tool in their toolbox.
I would suggest that I will a second Representative Pro. I would suggest that the government already knows via when a firearm is purchased from an FFL dealer, they have a track of every weapon they sell, so they know that these weapons are being sold, and reports are made to the federal government from the FFL dealer of their sales. So, and the ATF can walk in at any time and see the list of all the sales they make, and they have to be provided. So there's already the ability to see it, but they have to have a reasonable cause to think there's a crime. They can't just screen everybody and say, well, that one might be criminal or that one might be criminal. Representative Prue, did you want to add to that?
Well, I would like to say that I don't know any terrorist or criminal, for the most part, that uses a credit card to buy their weapons. They're usually black market weapons that have been stolen already, so they can't be traced back to them. So they're not using credit cards. And as I continue on this, usually most transactions over $10,000 automatically get flagged to the government. So if you're spending $20,000 on anything, it gets flagged, or $10,001, or actually 10,000. And to Representative Muse, social media, yeah, they may point it out to the government, but that post is already in the public, so you're not reaching into their secret private stuff. They already put it out there, and somebody just says, hey, did you see this? So I think that's a little bit different than me using my credit card and my company telling the government everything that I'm buying.
Good points. Who's left? Representative Pratt.
I was going to speak to an earlier statement about list. If you put on a list, if you use your credit card to buy marijuana legally in New Hampshire, that could possibly put you on a list. Right now, federally, it's against the law. Now you're on a list. So just keep you in mind as the lists start getting built by what you buy on a credit card, it can be used for everything.
I believe you can't use a credit card in New Hampshire. Can you? No, but I think in Massachusetts you might be able to at their open. No, as far as I know, it's a cash and carry business because of the federal government. Representative Jambrin.
Thank you, Mr. Chairman. I did want to point out, I did mention California this morning. So I'll clarify what I meant by that. The reason that the credit card companies paused this policy, when it was announced in 2022, there was such pushback and several states passed laws outlawing it, much like this bill would do. And those passed and were signed into law. Those 7 states are the states that stopped the credit cards from companies from doing this. That's why the policy was suspended, so that they would have time to either work through the federal government to make it a federal mandate or to prohibit it throughout the states. There is a patchwork now. The California, it was on my way here. Saw it on CBS News feed. California requires this to be used. And they also require the agencies that use the credit cards and make this list to share that with the Department of Justice in California. Again, we live in the live free or die state, not the whatever they call themselves over there. I call them the left coast, so I'm trying to be polite about it. But the reason that it was suspended is because several states voted to prohibit the use. The only state that has mandated that it be used is California.
Representative Sitek.
Has anybody noticed when somebody says, I'm not going to repeat previous arguments, then they go and repeat all those previous arguments? Well, I'm not going to do that. The obvious thing that I've not ever heard it mentioned in the entire discussion. You take your card, go down and get cash and go back and buy it on a cash basis. Nobody's even mentioned that as far as I know. See,
I'd be happy to respond to that. I've bought numerous firearms and I buy them online, and they don't take cash, unfortunately. When you do that, you give them your credit card. They take the firearm you purchased, they send it to an FFL in your state. You go to the state FFL, they do the background check, and then they give you the firearm. There's no way to give them cash, so that would eliminate that. Representative Bolden.
Going back to the earlier topic of terrorism, it's my understanding that the 9/11 hijackers did use credit cards in part to fund their activities, and this does seem like it could create some problems for federal law enforcement to be able to prevent terrorist behavior.
Yeah, they I think they used the credit cards to buy plane tickets and perhaps box cutters, but they didn't use firearms. Representative Wheeler.
Thank you, Mr. Chairman. I would also just like to say, because profiling is brought up so much in this committee, that I would caution us to use the arguments about terrorism just because anybody can be a terrorist, as we've seen in the mass shootings and what we've seen recently. Anybody could be a terrorist. You could look like anything and act like anything. And I think, as you said, it gets into dangerous territory where if we start discussing things like that, as is being discussed in the NSA and other domestic intelligence agencies, then we start getting into a situation where we're screening every gun owner who wants to purchase a gun for terrorism, and that gets into privacy concerns as well.
Representative Stone.
Thank you. And to respond to Representative Sitek, most your 2 popular day for gun buying is usually weekends, and ATMs limit the amount of cash you can get out of an ATM. So $500 is not a big threshold for a new firearm today if you haven't bought one recently. Maybe you could get a High Point.
Which reviews are actually pretty good on High Points. They are odd-looking firearms. Representative Murray.
Thank you, Mr. Chair. Yeah, this discussion has enlightened me a little bit, and I think I entered this understanding that the data wasn't going anywhere, and we've heard differently based on this conversation. I do want to say that LGBTQ issues have been named a couple times, and from my understanding, many of the people in this committee voted against a bill that we had before us on the floor to protect people who come here to the state to get LGBTQ surgeries, and I believe that from getting subpoenaed from other states that they come from that have made laws against those surgeries. And so I think I would just ask, like, if I join you in this, that you be consistent in that logic and protect people, trans people in the future who are getting persecuted for having surgeries, and that kind of those kind of expenses being tracked by the government.
I would happily sign as a co-sponsor today about anyone getting information about purchases used for LGBTQ or frankly abortion or anything. We can debate policy all day long, but when we let the government get into taking over that for us, we can no longer debate that policy because it's set for us by mandate. Representative Bolden, are we going to terrorists again?
I'm pretty sure you can take more than $500 out of an ATM. I've done that recently. But if we're all in agreement on the things that we don't want tracked in these purchases, can we pause, amend the bill to include language related to abortion and LGBT issues, and then pass the bill?
It's not germane.
I believe it is.
We'd have to get a ruling, but it's an early bill, so we got to take care of it today. I am going to call a brief recess because somebody wanted to caucus. Yes, and we'll take this up again in a couple minutes. Okay, I'm reopening the executive session on House Bill 1186. And when last we spoke, there was some discussion about moving forward. Did anyone want to add anything else? Okay. The motion on the floor is inexpedient to legislate, I believe. And I'd ask the clerk to call the roll.
Vice Chair Rhodes,
No.
Representative Pratt,
No.
Representative Sitek, Representative Prue,
No.
Representative Janvin,
No.
Representative Mannion,
No.
Representative Reed,
No.
Representative Stone,
No.
Representative Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes no. Representative Newell,
No.
Representative Sue Newman,
Yes.
Representative Wheeler,
Nay.
Chairman Roy.
Chair votes no.
7-12.
7-12, the motion fails. Would anyone like to make a new motion?
Mr. Chairman,
Yes.
I make a motion to pass with amendment.
Do I have a second?
Second.
Seconded by Representative Stone. This would be a motion to adopt an amendment. What's the amendment number?
Mr. Chairman, the amendment number is 2024-0604H.
Would you like to speak to your motion?
Absolutely. The amendment that you received a copy of this morning was at the request of the New Hampshire Bankers Association and the folks that represent the credit card companies to the legislature. They came to me, I believe it was Friday, with a bunch of textual changes that they wanted to work with. And what we've done is under the Firearms Code, we've changed it to category 5723, which is what the International Organization of Standardization came up with. And we also made the issue of penalty for the payment card network. It's not specifically a credit card or the banks that are doing this. It's the transmitter of the transaction. And the second change that this would make is under the enforcement, it would place it before a court of jurisdiction that has jurisdiction over it, that they can seek an injunction, and they may also recover a civil penalty at the discretion of the court. So there's no blank $10,000 fine or penalty. I'm sorry, it's not a fine, it'd be a penalty. So those are the two changes that are in this year. And you'll notice that the change from the original bill to this one adds the payment card network as a chapter so that it can be utilized further in the section.
Thank you. Representative Stone, would you like to speak to your second?
Mr. Chair, I'd like to add that I think these changes to the original amendment is actually something that's going to be beneficial and I can support fully.
Thank you. I'll start discussion by asking a question. When you talk about processor, you're talking about companies like, for example, Square or some kind of a merchant processing system where they actually are a go-between between the retailer and the bank. Is that correct?
Yes, Mr. Chairman. If you go into a Walmart today, the credit card terminal that's there is actually using the network. And there's, I believe, 7 or 8 different ones nationwide, and it could be any of those. Those are actually the companies that assign the commercial code for that terminal. So, yes.
Thank you. And one last question. You spoke to, I believe the company was American Express. Were they against this bill, or were they happy to comply once you made the changes?
Mr. Chairman, they took no position on the bill. They just requested that the language be changed to be a little bit more succinct.
Thank you. Further discussion on the amendment? Seeing none, I'd ask the clerk. Oh, sorry. Go ahead, Representative Murphy. Sorry.
Thank you. My question is whether or not the fiscal note that was attached to the original bill still applies. That it said the methodology requires the Attorney General to conduct investigations, and the estimated cost for the two positions is about $90,000 per year. Is that still applicable, or does the amendment change that?
Representative, I would actually counter with the fact that Representative Muse said. Right now, they've suspended the use of this code nationwide. with the exception of California, that required it by under statute. And the reason they did that is because the several states had made it illegal. Because it has been paused, if we come in with this bill and it passes and is signed into law, the credit card companies and the transmitters have no intention of utilizing that code in the state of New Hampshire. So the $90,000 that was quoted in the fiscal note, we don't anticipate that there's going to be any expense because they will voluntarily comply with that. And that was the consensus I got from them this morning when I spoke to them in the hall.
Thank you.
So to be clear, the cost will be zero as long as the credit card processors comply with the law.
That's correct. And they have indicated they voluntarily will be adhering to the law.
And should they not, does this not allow for them to be assessed a civil penalty that could be used to reimburse the Attorney General's office for their expenses?
Specifically, yes. If you look at in the amendment, line 36, the Attorney General may recover reasonable attorney fees and other reasonable expenses incurred in the investigation. So that $90,000 effectively would go away, yes.
Thank you. Further discussion on the amendment? Seeing none, I'd ask the clerk to call the roll. The motion is to adopt the amendment.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Sue Newman,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
19-0.
19-0, the amendment number 0604H is officially adopted. Can I get another motion? Representative Janvrin,
Yes, I move ought to pass as amended.
Second.
seconded by Representative Stone. Would you like to speak to your motion, Representative Janvrin?
Mr. Chairman, I think we've covered the subject matter, and thank you very much for the opportunity.
Representative Stone, would you like to speak to your
Mr.
second?
Chairman, I concur that we've had a lengthy discussion. I'm all set.
Agreed. I don't think anything's changed, so unless someone wants to add something further that we haven't already discussed, Representative Newman?
I voted for the amendment because it makes this bill a better bill. I still think it's a bad bill. I think it's unnecessary. I think that we're involving the Attorney General to look after people that are just designating merchandise as actually what was sold, and that there's no need to it. This doesn't mandate anything at all. It just does not prohibit them from doing what they feel they ought to be doing. I don't know, maybe it has to do with merchandise restocking or whatever, but I think that the mandate is really a mandate that they can't do what they want to do. So I'm going to vote against this bill.
I would respond by saying it's a mandate that they don't share my private transactions with the government, and that's what the mandate is. Representative Stone.
Thank you, Mr. Chair. I'd like to point out that we're interacting with processing companies. They hire pretty high-end attorneys that help keep their funds where they belong in the profit margins. And once a state would make a policy like this, they will adhere to it so that they do not pay out additional funds to anyone that they don't need to.
With that, I'd ask the clerk to call the roll. The motion on the floor is ought to pass as amended.
Vice Chair Rhodes, Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvrin,
Aye.
Representative Mannion,
Yes.
Representative Reed, Representative Stone,
Yes.
Representative Gathright, Representative Muse,
No.
Representative Bolden,
No.
Representative Bradley,
No.
Representative Murphy,
No.
Representative Newman.
No.
The clerk votes yes. Representative Newell,
Yes.
Representative Sue Newman,
No.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
12-7.
12-7, motion carries, ought to pass as amended. I need the majority and minority report before you leave today, please. Thank you. With that, I close the executive session, and I hereby open the executive session on Bear with me until I find the right piece of paper. House Bill, we're going to skip 1330 for a moment. We're waiting on an amendment. We're going to move on to House Bill 1337. And I recognize Representative Bradley to make a motion.
Thank you. I recommend to ITL HB 1337.
Have a second.
Second.
Seconded by Representative Stone. Would you like to speak to your motion, Representative?
I would, thank you. HB 1337 will put victims at an increased risk. It also puts a burden on the victim to prevent their abuser from accessing deadly weapons. HB 1337 also makes unnecessary changes to RSA 173-B, a statute intentionally written to establish protection and enshrine best practices when it comes to responding to domestic violence in New Hampshire.
Thank you. Representative Stone, would you like to speak to your second?
Mr. Chair, I would. I think 1337 had good intentions. I think there was a lot of work that needed to be changed in the bill. And I think removing anything from the 173B section of RSAs is problematic. And that's why I would be supporting the ITL.
Thank you. Further discussion? Seeing none, I'd ask the clerk to call the roll. Motion on the floor is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek,
Yes.
Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Sue Newman, Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
19-0.
19-0, the motion of inexpedient to legislate carries. Any objection to consent? Seeing none, it's going on the consent calendar. Representative Bradley, I need the report today, please. With that, I close the executive session. I hereby open the executive session on House Bill 1339. I recognize Representative Stone to introduce an amendment.
Thank you.
Yes, sir.
This bill has actually been amended
No,
This bill has actually been amended in a form that's extremely different from the original bill. The original bill essentially would have extended the role of the New Hampshire State Police in doing firearms background checks to long guns as well as handguns. What this bill does is it essentially changes the process for returning of firearms after restraining orders. My issue is not necessarily with the amendment that Representative Stone has created. My issue is more one of process. My understanding is that this issue was brought to the attention of the chair last week. One of the consequences of doing it this way is because this is the equivalent of a brand new bill, it has never really had a public hearing. It's not really germane. There may have been people who would have liked to have testified on this bill one way or the other, who were not able to do so because it was never really identified like that. So I know that we're in a little bit of a pickle with early bills, but I do think that this is something that from a process perspective, we do need to pay attention to things like this.
thank you, Representative. Representative Stone, would you like to address the germane issue on this, please?
I would, Mr. Chairman. This amendment is under Amendment 0605H, and it is germane to the heading. It puts a lot of the responsibility on the New Hampshire gun line, which is administered by the New Hampshire Department of Safety, which they have significant role in. And therefore, I feel that this bill fixes some issues we've heard with other bills that were brought before us previously. In addition, it also addresses some of the issues that was identified in 1337 as being problematic for its change in language for 173B. This bill wasn't properly noticed as a subcommittee, and the public was noticed to show up, and we actually pretty much had a public hearing where we heard the concerns of both the New Hampshire Department of Safety and from the Domestic Violence Coalition. And I believe Chief Goldstein spoke on behalf, it's either the New Hampshire Chiefs of Police Association or the New Hampshire Police Officers Association.
And when you had the amendment drafted, did OLS indicate to you in any way that this was a non-germane amendment?
They did not.
Thank you. Representative Muse, your objection is noted. And you are free, obviously, to speak to the clerk and the speaker after, and if they so rule, then I guess the bill will go into nowhere land. I'm not sure what happens to it at that point. With that, I introduce your amendment, please. Actually, you have to need a second on it.
Second.
Second by Representative Janvin. Would you like to speak to your motion?
Yeah, I'd like to clarify that this motion, this amendment basically changes the word after speaking with the Department of Safety, in which they felt they could work with the parameters of may versus shall, which was the only real change from what I refer to as McGue amendment that was initially put forward at the subcommittee. And I believe the Domestic Coalition had no issues with the way the bill was written. And basically, this bill adds timeframes for the judicial aspect of returning your firearms. Does not negate any background checks, but actually sets forth that the court would have approximately 10 business days to schedule one. And it also get a response from the NICS line, which is administered by the Department of Safety, Division of State Police.
Thank you. Would you like to speak to your second, Representative Janvin?
I concur with his comments and I defer.
Representative, if you could, for mine and the rest of the committee's education, walk me through what this actually means mechanically as far as someone has an order and their weapons are seized.
Mr. Chair, I'm going to use the example of just a restraining order that it's expired. Upon expiration, there is no paperwork that's generated. It just gets out of the system, it shows it's expired, and it's no longer valid. An individual who's previously prohibited from purchasing a firearm or possessing a firearm can actually go as soon as the order is expired and buy a new firearm. However, that individual cannot simply show up at the police department and say, I'd like my firearms returned to me that you seized. They would have to be doing a motion with the court. Previously, there was no time frames. The court could determine it on their schedule. This would provide guardrails of 10 days. Once the order is given, the NICS background check would be initiated by the request of the court. It would then be approved by the judge. All parties obviously would be noticed that have invested into the hearing. And at that point, the judge would make a determination to direct the law enforcement agency that seized the guns to return the firearms. Basically, the premise is the co-sponsor, Representative Mannion, brings out if the orders are done by a court to take firearms, then it needs to be an order given to return the firearms, which gives most law enforcement agencies a comfortable feeling knowing that they have a document they can have that says we were ordered to return firearms and put in their file either electronically or in a hard copy.
Thank you. So basically, distilled down, what this does is it stops the process whereby someone has a restraining order against them, the order expires, they're free to go buy all the firearms they want at a store, but in order to get their own firearms back that were seized, they had to go to court and go through a process that could cost them more money and time just to get the firearms back. This alleviates that.
Mr. Chair, it does. And another thing this also does is the state does not want to be holding on the responsibility of anyone's property if there's no legitimate legal reason to do so. And most agencies I've spoken to in regards to this issue are accepting of this because they want to get these items out of their evidence rooms as well. And if there's no legal basis for the state to be holding something, they shouldn't be incurring that liability either.
And what if any pushback was there after you amended it? Was there any pushback after you had it finally in its final form?
I believe all the shareholders that were here during this process were pretty confident with the language as it was amended.
Thank you. Further discussion. Representative Rhodes.
Thank you, Mr. Chairman. If I may ask a question of Representative Stone.
Go ahead.
And could you just, my question is was the New Hampshire Coalition, were they here for your subcommittee? And if they were, could you just give us some feedback that they spoke to at the bill?
They were, and I hope I met all their concerns. Their biggest concern was the fact of not having background checks done. I think that was satisfied, and I'm not sure if she's still here or not, but she was here for the subcommittee, and their big concern was making sure that there was, in fact, a NICS background check conducted before issuing the firearms back by the court. And as I advised her, as I did many, that usually the court of jurisdiction that has authority over this is usually the court that issued the orders for domestic in the case of 173B. So they will have the file. And in a course of regular business, as we all know, most of the communities, they have frequent flyers, same individuals. They know who they're dealing with. They also have access to the New Hampshire court database, whether it be Superior Court or it be Circuit Court. They have all the information they need. It gives them a next step to use the next line to be able to validate there's not an outside order. And the reason for the changing the word from shall provide a response to may is that the state police felt it was imperative they'd be able to give a response in the case of, say, Massachusetts. They reach out to a Massachusetts court. The Massachusetts court says, yeah, we'll get right back to you. They never hear from them again. They'd at least be able to produce a letter and document to have a cover letter to say, look, we've done everything. We found no prohibitions, but we have no response from this, say, hypothetically, the Lynn, Massachusetts District Court. They never provided us with a response, but from our end, we don't see any reasons not to return firearms.
And with regard to that point, if a court in Massachusetts had in fact entered a new restraining order or a conviction of some type, that would show up in the next check anyway. Is that not true?
Yeah, the restraining order would be in NICS
Thank you.
and spots.
Representative Newman.
I just have a question, since I believe this is the first time we've seen this amendment. Is that correct? That's a question for the chair, I think.
Other than the subcommittee, yeah, that's the full committee's heard it, yeah.
And did we get a report from the subcommittee? That's a question for the chair.
I believe that Representative Stone is talking about it right now.
I mean, was there a vote taken, or I'm just wondering if
There was no vote taken at the subcommittee. The majority consensus was to return to the full committee for the executive session.
Okay. And now can I have a question of the
Absolutely,
representative? Could you just point out where the change from shall to may is? I see some shall nots in there, so I see a bunch of shalls.
I'm sorry, that would be on line 31 on the first page. Beyond the 30, prohibited from possessing a firearm within 10 business days of the court's request, the Department of Safety may provide a proceeded response to the requesting court. So previously it was shall, which, as we know, shall is you will do it, versus may, which gives the option.
A follow-up? And so, but I do see there are still several shalls in here. The court shall not be required to request, conduct, or receive the results of a background check. Draw my question because I want to read that more carefully.
Representative Stone.
There are occasions. This bill also covers issues other than 173B. 173B and 633-3 are domestic violence and stalking. Nothing prohibits a police department in other circumstances, such as a bail condition ending that's non-domestic related, from firearms being returning. But it also seeks out, if the individual police department does not want it to go to, if they just don't want to give the guns up freely, they can actually request a court action. But the protections for the domestic coalition was more geared towards the 173B protection and the 633-3.
Thank you. Further discussion? Representative Murphy.
Thank you. Thank you for taking my question. My question was on page 1, line 28, 29. Can you clarify what circumstances would lead a NICS check to come back inconclusive?
That would be the example I gave of an out-of-state court, which refuses to cooperate with New Hampshire, and then New Hampshire has they can't force Massachusetts to cooperate. And a lot of times, probably less than, I'd say, 3% in the firearms industry do you get a non-response back. It's been my experience. I know that generally you either get a denied or an approval pretty quick. The delay usually responds for further information inquiries. And this is not 100%, you're going to definitely get a response back, especially if you're doing without a states like bigger states like Florida, even California. An inconclusive is only for saying we're not sure what the classification of crime. In the old days, in the state of New Hampshire, domestic violence complaints were actually just a red box that was checked. Since we've evolved, technology has gone further. You may still have some individuals that have to go pull a manual complaint and see if that box was checked, or read the body of the complaint to see if it was a domestic that meets the federal requirements under their definitions of domestic violence.
Could you clarify though, I have a question. So when they do the NICS check, the instant background check, it's going to come back with, it doesn't come back with an inconclusive.
No, there's only three statuses. It's either approved, denied, or delayed. Delayed is usually the one they have to clarify if there's a, say like in the case of a simple assault. If you're a simple assault and it's just straight up simple assault, non-domestic related, that's not a lifetime prohibition. If you have a domestic simple assault and that's codified and shown to be the case, then you are a prohibited person.
So, but the delayed doesn't put the onus back on the local police to follow up with other courts. It's the FBI who has to follow up to.
Correct.
Is that correct?
In the case of the gun line, if it's a handgun, then they'd be the ones making the phone call.
Right. So when you were saying some courts might not be responsive in Florida or California, that would be to the FBI's inquiry regarding the original record.
It could also be to the New Hampshire State Police.
Okay. Yeah, through the gun line.
Yes.
Okay, correct. All right. Further questions or Representative Newell?
So I just want to ask, I know that these were along the lines of the concerns that were raised by the coalition, the Domestic Violence Coalition. And I'm just wondering, since this is dated today, if they've actually looked at the language and.
Yes, I provided them with a copy as well as the state police that were represented here today. And I wanted to make sure that they had no more concerns going forward on this.
Thank you.
Okay. Seeing no further, the motion is to adopt the amendment. I would ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sytek,
Yes.
Representative Prue,
Yes.
Representative Janvrin, Representative Mannion,
Yes.
Representative Reed, Representative Stone,
Yes.
Representative Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Sue Newman,
Yes.
Representative Wheeler. Nay. Yay. Chairman Roy,
Chair votes yay.
19-0.
19-0, the motion, the amendment 0605H is officially adopted. We'll entertain a motion from you, Representative Stone.
I'd make a motion ought to pass 1339 FN.
Is there a second? Ought to
Second.
pass with amendment, by the way. Seconded by Representative Prue. The motion ought to pass with amendment. Would you like to speak to your motion?
Real briefly, Mr. Chair, I'd like to just reaffirm that this does not do anything but add timeframes for the court to assess and issue out a hearing date. The firearm background checks would be completed as required previously.
Would you like to speak to your second, Representative Prue?
Negative.
For discussion, I just want to, for the record, clarify, the only thing changed with regard to returning firearms to someone who had a previous protection order against them is that now there's a time frame by which the court must issue an order giving it back, whereas before it could take forever and they had to go to court and request a motion to return them. Is that correct?
That is correct. It sets a 10-day window that they have to hold a hearing.
Thank you. Further discussion. Representative Muse.
I would say what this bill does is it points out the continued need for people who are in domestic violence situations and who have filed protective orders, if they feel that there are circumstances that would lead them to try to have those orders extended. Those are things that they're going to need to go to court to do, and they're going to need to show up to do that. I don't think it's fair to depend on an inefficiency in the system to keep people away from even things like firearms that are their property unnecessarily. So what this bill does, as the chair said, is it adds some more specific timeframes. It adds some guardrails around a set of circumstances where the guardrails, I think, were a little bit ambiguous before. So I'll support it.
Thank you. Further discussion? Seeing none, the motion is ought to pass with amendment. I would ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sytek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Gathright, Representative Muse, Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Sue Newman,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
19-0.
19-0, unanimous. Any objection to consent? Seeing none, it will go on consent. I hereby close the executive session. With that, I open the executive session. What? Which one? Do I? Stand by. All right. With that, I open the executive session on House Bill 1658, and I recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move ITL for House Bill 1658.
Seconded by Representative Wheeler. Would you like to speak to your motion, Representative?
Yes, Mr. Chairman, thank you. I understand the genuine concern that the sponsor and the co-sponsors had with bringing this legislation forward. But when we heard the testimony, it seems that could cause actually will be a huge invasion to privacy for any patients. And it seems to me that if there are mechanisms in place that if you have a loved one that, you feel that, has medical conditions that, these situations may arise, you are able to get guardianship. And when you have that guardianship, then you are able to put this out to the public. But to just say that somebody's medical information should be shared because you feel that their safety may be endangered, you really just can't do that. And additionally, we did pass a bill last year that does allow, there's a checkbox, if there's an elderly person that has, medical conditions, maybe they have Alzheimer's, this may be something that can be addressed in that way. But to just basically say that, a person's been in and out of the hospital and we want to share that information with the public is something I just don't feel that is right to do.
Representative Wheeler, would you like to speak to your second?
I think Rhodes did it perfectly.
I would say this, that I think that the intent is laudable, and I think that there may be a way to do it, and I think the sponsor should not give up and come back with a better crafted bill that includes input from all of the stakeholders, then we might be able to do something. But it occurred to me, if there is such a database, there are departments in the state that don't have mobile data terminals, and if they need to query or dispatch regarding something like this, and they don't have a secured channel, they're going to put someone's medical information out over Scannerland where people in their homes are going to sit there and listen to and know all about the person's medical history. So it needs a lot of work. With that, further discussion. Seeing none, the motion is expedient to legislate. I'd ask clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvrin, Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Gathright, Representative Muse, Representative Bolden, Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman. The clerk votes yes. Representative Newell,
Yes.
Representative Sue Newman,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
19-0.
The motion of an expedient to legislate carries by a vote of 19-0. Any objection to consent? Seeing none, I hereby close the public hearing. I open the public hearing on House Bill 1462 and recognize Representative Murray to make a motion.
Thank you, Mr. Chairman. I move interim study for House Bill 1462.
Is there a second? Second, Representative Stone. Representative Murray, would you like to speak to your motion?
Yes, it would. Thank you, Mr. Chair. During the hearing for a similar bill in the Senate, after working on this bill initially with the AG, we found out that the state police is already collecting a lot of this data, and we need more time to ensure that the bill is written in a way that does not conflict with the processes that are already in place. So I would hope that the committee would be happy to continue work on that language.
Representative Stone, would you like to speak to your second?
Mr. Chair, I would concur with Representative Murray, and I think it's prudent to refer it to a committee to do further studying.
Further discussion? Seeing none, the motion on the floor is interim study. I would ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative James. Bradley, Representative Murphy,
Yes.
Representative Newman,
Yes.
clerk votes yes. Representative Newell,
Yes.
Representative Sue Newman,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
19-0.
The vote of 19-0 for interim study carries. Any objection to consent? Seeing none, goes on consent. I close the public hearing. With that, I open the executive session. With that, I open the executive session on House Bill 1701. Who would like to make that motion? Representative Newell, would you like to make a motion?
Yes, I'd like to make a motion to ITL.
Is there a second?
Second.
Seconded by Representative Murphy. Would you like to speak to your motion, Representative?
Sure. As written, this bill had some serious flaws. The timing was off. It was talking about from 5 years from the date of commitment rather than the absolute discharge. There was also unclear language in here. Who is a medical professional? There were a variety of problems that kind of sabotage the intent of the bill. And I think the comment was made in this as we were talking about it for the authors of the bill to bring forward an amendment that might fix those problems, and they didn't do that. So.
Okay. Would you like to speak to your second, Representative Murphy?
Yes, thank you. Some of the testimony we received was that there was concern that if this information was annulled, it would not be available for those healthcare providers' use in determining dangerousness, et cetera. So I would support the ITL.
Thank you. I would add that mental health, like any disease, can reoccur at any time, sometimes years later, and someone may get better for a while. And without being able to look back on the medical history, which may include a commitment, really hamstrings a doctor's ability to further treat that person. And the motivation for that is, I just don't understand it. So with that being said, Representative Wheeler.
Thank you, Mr. Chairman. I think Representative Newell and yourself and Representative Murphy did a good job at explaining why the ITL on this bill is a good thing. The New Hampshire hospitals came and testified about how it might hamstring their ability to bring consistency of care to a patient who comes to the hospital. And I think that's something that should be, that's a concern. And I think as the bill is written, it would allow for violent people to get some of their rights back, which is also a concern. But I do just want to say, for the sake of Representative Reed, who brought really powerful testimony about her story of what she had gone through with domestic violence and with other things, and having the process that she went through result in her not being able to defend herself, I think is a concern. And hopefully in the next biennium, someone is able to bring up legislation which addresses that and make sure that people who are no longer a danger to themselves or others are able to defend themselves in whatever way they see fit, as Representative Reed brought up here to the committee.
I do not believe I was here for that testimony, but it sounds like it makes sense based on the short recitation you've said. I would remind you that another bill that I and Representative Muse are bringing forward allows people to have their rights restored who may have at one point not been able to have them, which is currently the state of affairs in New Hampshire. Further discussion. Representative Muse.
I just wanted to add that this, I think that this bill is very well intentioned, but what it does is it treads on the same ground as HB 1711, and the ATF is very specific around the types of programs that will actually certify like this. And I think another thing from a mental health perspective is what 1711 does is it looks at unconditional discharge as being the proper gate to look at in a situation like this, not just necessarily the expiration of time, because as Representative Roy said, mental health can be an ongoing struggle that can last for years. And it was also pointed out to us in committee that a person can actually be involuntarily committed for up to 5 years in New Hampshire. So if we have a bill that says that essentially they can have their firearms back at the end of 5 years, you could have a person conceivably walking out of New Hampshire Hospital one day and buying firearms the next. So there are issues with this particular bill that I think are more effectively dealt with in other legislation that's before us.
Thank you. Seeing no further discussion, the motion on the floor is inexpedient to legislate. I would ask the clerk to call the roll.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sitek?
Yes.
Representative Prue?
Yes.
Representative Janvin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Gathright? Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Sue Newman?
Yes.
Representative Wheeler?
Yay.
Chairman Roy?
Chair votes yes.
19-0.
Any objection to consent? Seeing none, the motion carries inexpedient to legislate. It'll go on the consent calendar. I close the executive session, House Bill 1701. And I believe we have one left, and we're still waiting. Yeah, we're going to take a 1 hour lunch break. I would suggest that everyone use that time to get the reports done that have to be in today, in addition to getting yourself a sandwich. And we will meet back here at 12:30. House Bill 1701 and invite I'm sorry, I don't even know where I am. Executive session 1337 and recognize,
1330, my friend.
I'm going home. Executive session, House Bill 1330 and recognize Representative Prue to make a motion.
I make a motion ought to pass on amendment 2024-0618H.
Is there a second? Seconded by Representative Stone. Would you like to speak to your motion?
Yes, I would. So this amendment creates a review panel for the Bureau of EMS. In the past, it's been one investigator, and not necessarily the same level as the person being investigated. So you could have an EMT investigating a paramedic and not knowing all the ins and outs of paramedicine. And I have seen that personally happen. So this creates a 3-member board of the same level or higher to take the information, make a determination. In the past, it has been the investigator gave the information to the Commissioner of Safety, who is a police officer, who has no EMS experience, making these decisions. So I think in all fairness, the person making these decisions should be their peers, same level or higher, 3 of them, looking at the incident and coming up with a determination. It also states that if they cannot come up with a determination in 90 days, the panel has to put in writing why it is going to be longer than that. And every 30 days after that with an update. There have been cases where it's been 11 plus months to get a determination. And I find that a very long time. There was very little communication back and forth on what was going on. And here you have this person wondering whether they're going to be able to take care of their family or whatever. Is their license going to go away? Is it not? And I think that's a very long time. The other piece of this is removes the web page that lists everybody that's had a determination or a finding in public view. This has been weaponized by some of the members of where maybe this person under investigation is working. I've had personal reports to me firsthand that, you know, somebody went under investigation, not too serious an incident, with people saying, hey, I can't wait to see your name up on the website. So I'd like that page taken down. The information will still be available with a phone call, an email, or whatever. If someone is truly interested in what's going on with that person, if they're going to hire them, they want their background, they can still get it. The other thing about that web page is that they had people listed on there that had passed away. And when the family members reached out, they were told, yeah, we can't take the name down. There's nothing in law that allows us to do that. So that person was going to live in infamy forever, even though they were dead and there was no way they were coming back to get a job. So that's pretty much what this does. I think it's fixing some wrongs that have been in the EMS system for a while. I've heard numerous, as I was looking to do this, numerous people who feel that they really weren't treated very well. And the process was kind of rough. So I would hope that members would vote with me to fix this issue. And if anybody has any questions, I'll try and answer them for them.
Thank you, Representative Stone. Did you want to speak to your second?
Thank you, Mr. Chair. I would. I think this process outlays a little bit more due process that's been afforded in the past, and I could see this as being a positive moving forward with professional licensing.
Thank you. I had a couple initial reactions. First, I was a little, I questioned the part about taking down the information, but now that it's clear to me that the information is not unavailable to anyone to check, it's just not published. And as this is, these are people that work for private companies, AMR Ambulance or something like that. It's I don't see a public interest in putting people's names. It's not like you can pick your own EMT. So you know, an ambulance comes, you can't go, oh, wait a minute, let me check and see that person's name. I mean, they work there or they don't. It's up to the companies to decide. And if it's open to companies to call and get a list of people or check on someone's history, then it's fine with me as long as it's available. I don't see the interest in the public to shaming people in regards to what happened in their careers. Also, with regard to the panel, I feel like it's, you know, when we look at medicine, the practice of medicine, doctors have a board. They have a peer review board in the hospital, and when it comes to their license, they also have a board of medicine that reviews what's done, and they're experts. They have the ability to get experts to look at every case, and it's never would they have, for example, an internist or someone there, you know, brand new out of medical school reviewing a surgeon, for example. So it makes sense to me to have someone of a higher or equal background and more than just one person making a decision on someone's career. So I'm gonna support this. I would ask the members to consider that and do so as well. Further discussion. Representative Wheeler. Oh, okay. Representative Harriet Gathright.
I actually thought that this was a pretty good bill initially. And what I did like about it was the 3-member disciplinary review panel. I thought that was a great way instead of having just 1 or 2 people making decisions like that. But when I go to page 2, Roman numeral 5, when it talks about the 5 years from the end of the licensee's discipline, that this be removed, I'm really not for that. I definitely believe that the second piece of that, where it talks about the death of a person, I am very much for that. I don't believe that once someone has left this earth that you need to continue disparaging them for any reason. So I'm going to say I'm not going to vote for this.
If I may.
Representative Pro.
So that piece was actually part of when the web page was up, that the names were supposed to come off the web page and go into the file and still be available in the file. There was an oversight on that not coming out. So I can make that come out. That information is still available. It's just not published on a web page.
Representative Murphy.
Thank you, Mr. Chair. I know I've spoken with Representative Prue. I like most of this bill. I still have concerns about the very last part. And I hear the history that he has and the experience he had about this information being weaponized. And I can see how that can happen. But I think those people that are going to do that, no matter what, whether there's a website or there isn't a website, and I see it as a transparency issue. I think as a retired nurse, I know that if there were disciplinary actions taken, not during the investigation phase, but upon a determination that information it's sent out in newsletters from the Board of Registration and Nursing. That information is on the Board of Registration and Nursing website, so that even if we don't pick necessarily an emergency medical personnel, if there is information that is publicly available on whether it's on certification or a board of registration, it may not make a difference right away, but if you're the parent, say, of a child who goes in an ambulance and there's a concern over whatever treatment, and then you go to look back about, you know, the care that your child may have received, I do think that that information should be available publicly, just as it is for the Board of Registration of Medicine or the Board of Registration of Nursing or healthcare providers. So that's, I still have that problem. The rest, I agree about the 5 year, excuse me, about the, when a person is deceased, fully support that. I also support the disciplinary review panel. I think that's a really good idea too. It's just, I'm just concerned about the transparency issue, and I don't know, it would be hard for me to support it with that still in it. Thank you.
I have a question.
Representative Prue.
Does the nursing board have a website that lists it?
I don't know, maybe. Yeah, I've not looked.
So that, I mean, if they have a website that
Did you
lists everybody, then I get it. But as far as I know, the EMS board is the only one that does this.
I believe you can look up a doctor. I don't know about a nurse, but there's no website like with a list right there.
Right.
You have to go in and click the doctor's name.
So, you know, that whole weaponizing thing, they have a big TV screen, and up on it is the list when that person is working, because they said, oh, we're waiting to see your name pop up. So it's not like they had to go look at their file, send a email requesting it or such, but it's just this big thing that's readily available. And
Representative Wheeler.
Thank you, Mr. Chairman. I have a question for Representative Pro, and you've kind of touched on this in saying that the finding or determinations of such investigations are not available via the internet or the website does not mean that this information is not available.
that is correct. If you
And-
call them and say, hey, I want to find out about Mark Prue, is he a good EMT? Does he have any bad spots on his record? They will tell you.
Can I have a follow-up? Then my next question would be, how would somebody go about getting that information? They would just contact the director?
Contact the Bureau of EMS, say, hey, we're looking to hire Mark Prue. Can I get his record? Is there any findings, you know, disciplinary findings in his file and that stuff?
So it's not a ban on
No,
allowing people
absolutely
to...
not, because I don't want a bad EMT coming to pick me up when I'm laying on the ground looking up, right?
Yeah.
I want to make sure everybody is doing what they're supposed to, and if they violated their oath and such, I want people to know about it. But I just don't want it out there weaponized.
Yeah.
And I that's what my point when I said about public shaming. It's different if you want the information to make a hiring determination or what have you, but it's different to just put someone's name out there for no other reason than to just say, hey, look at this person did. That's the point I was making. Representative Stone.
Thank you, Mr. Chair. Under Section 5, does anything prohibit a director from not removing it if they deem it to be an issue, such as maybe a person shouldn't hold a license for the rest of their career?
So can he leave it up there?
Correct. Is that at his discretion?
As it stands right now, they can't remove it once it's on.
But your bill would allow them to, if they determine to remove it.
Right.
Is that the way I'm reading it correctly?
No, it shall.
So I imagine, so if you read it, it's 5 years after their discipline is over. So if they were permanently revoked, there's no 5 years after that. They're revoked for their lifetime. When they pass, then you could remove them
So follow up, that'd be a permanent record if they're revoked.
for a lifetime. Yep.
Correct.
Representative Muse.
Thank you. I think one of the things that we need to pay attention to in this is, I think there's a difference between intent, which I think is good, and the actual language of the bill. So if you take a look page 2, line 9, it says, "The director shall not publish or make public any ongoing investigations, including the findings or determinations of such investigations via the internet or website." So I think one of the things that we need to be extremely careful about is creating a situation where there really would be any less transparency when it comes to these investigations than we have now. I think saying the internet or website, it's extremely broad. What do we mean, exactly, by that? It just strikes me that the language that we're using here is overly broad, and in the end may not actually accomplish what the sponsor's looking to accomplish without creating some unintended consequences.
No. Yeah, right. A second.
Representative Murphy.
Thank you. I looked up the information that I would like to see retained in these situations if a determination has been made is similar to the New Hampshire Office of Professional Licensure and Certification. I looked at the Board of Nursing and how we do it. And the Board of Nursing Actions retains the disciplinary documents on this website for a 7-year period. You can look it up by year, and you can verify licensure. So that's the part that I'm looking to. I think I agree with you. I just think that what this says is that there's no documentation, and it can be just, so if there's a way to say that this information would be kept on something like this, I think that makes sense. But it's just right now, it's just too broad. It's basically, the way I read it, it just says that there's going to be no publishing of determinations of investigations on the internet or website. So that would make me think that it's meant to preclude something like this. And I don't think that's what we want to do.
It sounds like Representative Peru, go ahead.
So I'll give you a history of my background that is really kind of driving this for me, is that I run the Granite State Critical Incident Stress Management Team, that we assist police, fire, EMS, and all emergency responders, including hospital staff, get through really bad calls and manage critical stress that leads to suicide, right? So my number one goal right now is preventing suicide in first responders, whatever that takes. And I try to remove any additional stress to them. And to me, this webpage that is just their disciplinary webpage, which I'm trying to get to here in a second, and it's not listed by year. It's just listed everyone, even if they're dead. So to relieve some of that stress, I think making it harder, just a little bit harder, that it's not so public and not so easily accessed by people who are just trying to weaponize it, right? They're not there because they're going to hire that person. They're not there because they have some issue that, oh, hey, they came to my house and that guy with a name tag, I want to find out about him. Sure, they can call EMS and say, hey, what about that EMT Mark Pro, right? What's the deal with him? Does he have anything in his background? As opposed to this big poster that, I don't know.
May I make a suggestion? It sounds like everyone in here agrees on a good portion of this bill, but there are some significant hurdles that are going to keep a majority to vote out to pass. I think that perhaps, given the time, because we don't have really the time to wait for another amendment, we vote however that comes out, And then Representative Prue and maybe Representative Murphy could work together because it's going to finance and you can be amended again in finance. But if we have to act on it today. So if you could get agreement and get an amendment in finance, and then before it comes to the floor with an OTP and enough people will commit, I think you can pass this thing this year. So what do you?
I'm willing to work with anybody to try and
Yeah.
get to where we need to be,
Okay.
because I truly don't want to make it impossible for people to find out about bad EMTs.
I think if
Because
you,
I don't want that either.
yeah, I think
Because
if you
one of
look at
these
the
days, They're gonna
language,
come get me.
right, if you look at the language, whatever the law is that allows the nursing to do that, it might already be there.
Right.
And you just take it and copy it and
Yeah,
so,
so I'll reach out to,
yeah, because let's get it out of here, send it to finance, you continue to work, see if, what division gets it, and
Right.
they might entertain your amendment. Representative Newman.
I just want to, this process, you would prefer we vote it in this condition that it is. And then if it gets to finance and finance does an amendment, or they don't agree with the amendment that they put out, then it gets passed the way it is.
No, I'm not asking you to vote. You vote however you want here.
No, I understand. I'm asking the process.
Well, let's say
that process.
Let's say we vote 10-10 or whatever we have here today, and it goes to finance, and finance tells him, nah, get out of here with your amendment. He can then go with the floor amendment. Or they could say, no, the money's not there. I mean, there's a lot of different scenarios. But in order to get the support of members in this committee, at least, that have said they would support it if it was changed, I would recommend that he do that, and there's an opportunity at finance. I would do it here, but we're out of time because of the deadline. So vote how you're going to vote. It's going to finance regardless. Even if it comes out of here, ITL, it's still going to finance. So there's another bite at that apple. Representative Pratt.
I might assume that in finance, they would address the inflation of the cost of this bill.
Would be the prime reason that they would deal
Thank
with it,
you.
yeah.
There is an inflation here.
Representative Sytek.
Although finance is going to look at the money, I think you've said something important, which is that this committee would send a wink, in effect, that we're willing to modify, fine tune the language to reflect what pretty much is the consensus of the good intentions of the bill. Something that's not been talked about, and I couldn't vote for this without that understanding, is this whole, I guess it's my ED&A experience, but the pool of applicants is appointed by one person. Is there a term? Is it an ad hoc committee? Is it, can he be, serves at the pleasure? That whole thing, that disciplinary review panel needs to be firmed up, specified something. But right now, he can appoint 100 people. There's no limit. It is not defined, and that needs to, for my vote, that needs to be, good intention or not, that needs to be adjusted or made definite as to how it operates, how it's appointed, whatever its term. I'm repeating myself.
Yeah, I thought it was in there.
I would suggest you look at it. Based on that, since we do have to move this out of here today, I think we've had enough discussion. What we'll do is we'll vote, and then it goes to finance. I'll send a note to finance and say that there were a couple policy issues that we ran out of time that we'd like to see, and I would appreciate it if they would entertain an amendment that was brought by Representative Prue. And if they will, that's good, and if not, he'll have to do it on the floor. But it sounds like if he fixes those couple things, he'd at least have the support of the entire committee. So, Representative Wheeler.
Just really quickly, Mr. Chairman, thank you. I just have a process question. I'm wondering, instead of having this motion go to ITL, would it be possible to bring this motion to the floor with an interim study, reverse that motion, and then amend it from there, rather than it go to the floor with an ITL motion?
I don't know that it would go to finance with an interim study. So that might happen and then we would reverse it and then it would go back to finance again. Or it would be recommitted. I mean, we can make a motion
It
to
goes to
recommit it.
finance immediately after our
Yeah.
committee.
It goes to the floor.
Oh, that's
Yeah.
yeah.
Yeah. So, yeah, I'm not sure what the best way to do that would be. Representative Stone.
Thank you, Mr. Chairman. Knowing that there'd be bipartisan support from Representative Prue and Murphy, I'd be okay with voting ought to pass at this time, and I'd support that.
Representative Murray.
Thank you, Mr. Chair. I was going to suggest maybe if Representative Prue and Murphy work on an amendment before this goes to the floor, and then we can just pass as a floor amendment, and then we send it to finance all set.
That said, that made much more sense than everything I said. If Representative Murphy and Prue work on it and it's going to come to the floor, you bring it as a floor amendment and then it will go to finance as an ought to pass with the policy part taken out.
Right.
And then they can just deal with the money. Yeah, the vote is what it is today, and then we can, it's Representative Prue's ball to win over the rest of the members on the floor. Yeah, so right now, currently before us is the adoption of the amendment, so we have to take that up first. So I'd ask the clerk to call the roll on the amendment. The motion is adopt.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Gathright,
Yes.
Representative Muse,
No.
Representative Bolden,
No.
Representative Bradley,
Yes.
Representative Murphy,
No.
Representative Newman.
No.
The clerk votes yes. Representative Newell,
Yes.
Representative Sue Newman,
No.
Representative Wheeler,
Yay.
Chairman Roy.
Chair votes yes.
Like I said, right in the pot.
It's 14-5.
Okay, the amendment is adopted by a vote of 14-5. At this point, we will, I need another motion. Representative Prue?
Representative Prue. Would you like to make a motion about the passing amendment?
Yes, I would love to make a motion of ought to pass with amendment.
Second.
Seconded by Representative Stone. Would you like to speak to your motion?
Close.
Sorry, I was trying to work on our amendment. So I think I've talked enough of this. We have a good plan to make the final amendment on that one little piece. We're looking to follow the OPC method, so I think if we can do that, we'll all be fine.
Representative Stone did. Okay, further discussion, Representative Janvrin?
Yes, Mr. Chairman, I would recommend that the report that's filed on behalf of the committee actually say that you guys are working on a floor amendment to be introduced on the floor. So
Yeah.
that would give everybody a heads up.
Thank you. Okay, who's gonna, once we vote, who's gonna write the amendment?
I don't know. He can write his.
That's the ought to pass.
Yeah.
So the,
So they
Who's
will
gonna
be
do IPL. Hey, Mark.
Here's. Okay.
majority.
Yeah, majority.
Yeah. Okay.
You're assuming
All right, with that, I'd ask the clerk to call the roll. Motion on the floor is inexpedient to legislate. Oh, excuse me, Representative Sitek.
ought to pass.
Yeah, that too, ought to pass.
Ought to pass with
All right,
amendment.
Representative Sitek weighs off. Motion on the floor is ought to pass with amendment.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sytek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Gathright,
No.
Representative Muse,
No.
Representative Bolden,
No.
Representative Bradley,
No.
Representative Murphy,
No.
Representative Newman.
No.
The clerk votes no. Representative Newell,
No.
Representative Sue Newman,
No.
Representative Wheeler,
Nay.
Chairman Roy.
Chair votes no.
8 to 11. Motion fails.
Okay. A new motion? I'll move inexpedient to legislate. Seconded by Representative Gathering. I think we've discussed it, so Representative, unless anyone else has something to say, that's Representative Muse.
I'd just like to call your attention to the fact that from a process standpoint, one of the things that is an option is all of our recommendations can be approved or defeated on the House floor. If the ITL motion is defeated on the floor, then a new amendment, a floor amendment can still be brought to the floor. So I would urge Representative Murphy and Representative Prue to continue working on that floor amendment. And we did this just last week. So this is not a shot in the dark. This is something that we can do.
I think that's what we said we were doing, right? Yeah, okay. So I moved to ITL. Who seconded that? Linda, all right. We discussed it enough. Please call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
No.
Representative Sytek, Representative Prue,
No.
Representative Janvrin,
No.
Representative Mannion,
No.
Representative Reed,
No.
Representative Stone,
No.
Representative Tenzar, or sorry, Representative Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Sue Newman,
Yes.
Representative Wheeler,
Nay.
Chairman Roy.
Chair votes yes.
Motion is 12 to 7.
Motion of inexpedient to legislate 12 to 7 carries. I will be writing the majority report. And who will be, Representative Prue, are you going to write?
I guess so.
Mine's pretty much going to say, look under your seat.
Yeah, that's what I'm gonna say. There's a floor
Yeah.
amendment.
Okay, thank you. Yeah. Yeah, okay. Well, look under there anyway, because you should know what's under your seat.
Mine's under my seat because I sit dead ass in the middle of section 3.
One other suggestion is that floor amendment, should it come, if it would be a great idea to get it to the members of the committee well in advance of whatever the House session is, so we can take a look at it and have a chance to discuss it. And if it looks good, then we can reverse this thing.
All right, everyone, enjoy the rest of your week. We're actually not here again till the 21st. What? Oh, my goodness.
Yeah, your mom's waiting.
Happy 31st, Linda.
Go ahead, Jonah. Throw a grenade and leave. Get out of here. Get into the airport. We do not.
Again, everyone,
apologize for
21st,
bringing a
we will be
dangerous
back again. So
committee.
that's next Wednesday. And I've scheduled next Thursday in case there's no house session. So let's see.
Did we officially close that hearing?